The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. The next case is in re J.E.B. 2. We'll hear from the appellant.
May it please the court. My name is Garen Michael, member of the New Hanover County Bar. Thank you for the opportunity to be in front of this court today. It's both an honor and privilege. It's my inaugural time being in front of the Supreme Court. I'd like to request on the front end to secure 10 minutes at the end of my 30-minute argument time for rebuttal. Chief Justice and Associate Justices.
So, counsel, that would be at the end of your first 20 minutes, I'm assuming.
Correct.
Total.
Correct.
And,
correct, Justice.
Okay, and you will have a yellow light on the timer to show you 2 minutes.
Thank you, Chief Justice. I'm here on behalf of April Allen on a very important matter. I appreciate the opportunity to be able to discuss her case with you today. This is a juvenile case involving termination of parental rights hearing and subsequent termination order, which terminated Ms. Allen's parental rights to her son, Jason. That order was directly appealed to this honorable court. Today I stand before you, or sit before you, seeking remand of this order, specifically due to the trial court failing to follow the clear statutory mandate, specifically statute 7B 1101.1 subsection D. Generally speaking, 7B 1101.1 pertains to the right and appointment of counsel for parents in termination of parental rights hearing, as well as the appointment of a guardian ad litem for parents in 2 circumstances. Initially, not an issue in this case, a parent that's under the age of 18. It's an automatic appointment of a guardian ad litem attorney in that case. And then the situation where we have in this case, where we have a parent that's deemed incompetent under Rule 17, which is a permissive appointment. The court has discretion to do that. I don't believe the actual appointment of Rule 17 is in any way at issue in this particular case, certainly not on my end. I think that was done appropriately by the court. I believe everybody was in agreement at the trial level that the appointment was appropriate for Ms. Allen under the circumstances. Main issue in this circumstance that we look at is the initial sentence in subsection D of 7B 1101.1, which specifically states that the parent's counsel shall not be appointed to serve as the guardian ad litem, and the guardian ad litem shall not act as the parent's attorney. It's 2 clear and distinct roles designated by this statute. I believe this court has recognized it specifically as recently as the decision in December, that these roles are different and distinct in that they have a parent attorney role, and that role obviously is geared towards the preparation and defense and to advocate and execute a trial strategy to try and protect the most precious of the constitutional rights, that being the constitutional right to parent your child. The Rule 17 role geared more towards protection of the due process of the incompetent parent, focusing there on the communication between the parent counsel and the actual client, and when necessary, of course, stepping in the shoes to make decisions on behalf of the client, behalf of the parent, to ensure the best possible results specific to the termination of parental rights hearing. I believe these roles are very distinct in the essence of not only what the duties are of the parent attorney and the GAL and the Rule 17 GAL, but also in sort of the dynamic that is that evolves between the individual and the client. I think the parent-attorney relationship in the GAL, Rule 17 GAL relationship with the client is sort of innately unique. I think there's a different level of trust and different conversations that are had, different points of emphasis between the parent and those 2 individuals in those 2 different roles. The statutory mandates in place for a very, very distinct purpose, which I've already alluded to earlier, which is to protect the parent's rights, ensure that they have full representation with both appointed counsel, and to ensure that they're able to communicate with that counsel and be able to participate effectively in the defense of their parental rights.
Counsel, if I could jump in just a second. So I want to be clear, I'm understanding. Is it your argument that the statute prohibits a GAL from asking any questions?
No, I don't believe that there's a prevention of asking questions. My argument would be specific to allowing a Rule 17 JL to essentially take over all the functions or most of the functions of a parent attorney, thereby acting as a parent attorney, as specifically indicated in subsection D as being precluded being for purposes of termination of parental rights here.
Well, there's no dispute that there was an attorney for your client in addition to the GAL, correct?
Agreed, Joe.
So what precisely are you arguing that the GAL did that the statute would prohibit?
Well, Chief Justice, I would say that my argument is probably best put towards actually the trial court's approach to this particular statute, and really disregard to this subsection. It was made clear at the very beginning of the hearing that parent counsel, Mr. Kikassi, was not able to communicate effectively with his client. He indicated to the court that the client was present and Allen wanted to hire him, wanted additional counsel to be appointed, and indicated that he did not believe he could proceed effectively. The court denied that request initially. The court did hear from Ms. Allen. Basically, there was a break thereafter. They came back. Parent counsel again requested the consideration of being released as counsel and indicated he was going to have a hard time proceeding based on their communication. And then the trial judge seemed to address the GAL, Rule 17 JL, indicating that she had two attorneys in place, that they could utilize a strategy between the two of them to decide how best to represent her, essentially locking the parent attorney, Mr. Kikassi, into a situation where he apparently felt the need to allow the Rule 17 JL to proceed and ask questions, cross-examining witnesses, basically taking on the role of parent counsel, which again, the statute prohibits.
I guess the problem I've had in this case, and frankly, we had another one, as you've already alluded to, that essentially the parent made the reverse argument in WK, and so you're in this case saying that the GAL did too much. The parent in the other case said you didn't do enough. It seems to me, both of these cases are asking us to engage in an exercise in line drawing that would be pretty difficult to manage. Is that an unfair concern?
I think that the line that has to be drawn is to make sure, and it's sort of why I would say that the trial court is where the error is. I don't think Rule 17 JL did too much and overstepped his bounds in and of himself. I think he didn't have any choice but to try to provide some level of representation for Ms. Allen under the circumstances, and because he had, as indicated in the record, a rapport with her, was able to communicate with her, and based on the trial court's directives to him, I believe he felt like he had to step in their shoes, and that's what ended up happening. But by doing that, we've completely, it's not a situation where there was some bleeding in, and maybe the Rule 17 JL did a little bit more than trial counsel, or a little bit more than it should have. But in this case, a big reading of the just the hearing portion, if you didn't have the pretrial, you wouldn't even know that Mr. Hargett, Rule 17 JL, was even the Rule 17 JL. You would think he was the parent counsel. He cross-examined 5 of the 9 witnesses. Parent counsel cross-examined none of the witnesses. Rule 17 JL made the only substantive arguments, including the argument at the close of the adjudication, arguing against grounds. Parent attorney did not make any substantive argument. I understand that opposition indicates that he did a question about the dependency ground. However, I would hardly find questioning whether or not the dependency ground was being voluntarily dismissed as advocating substantively, considering we're in a termination of parental rights hearing where only one ground is necessary to proceed to disposition.
Is there any basis for arguing practically that your client suffered any harm as a result of the way this case was tried, short of simply that, at least in your view, the statute was violated? Is there any harm beyond that?
Well, Judge, I would go back, if I may, I would go back to my indications earlier about the sort of the roles of the two. There's different preparation that goes into it. It's different conversations had with the client. The parent attorney is going to be responsible for knowing all the discovery, the ins and outs, prepping questions for witnesses, all of these things. As a Rule 17 JL, your preparation for a termination parental rights hearing is very different. Again, you're focused on, does the client understand what is happening? Is the client able to communicate with trial counsel? And do they understand the proceedings, things of that nature? In this case, the Rule 17 JL actually indicated at the outset of the case that he had no idea that there was any communication issues between Mr. Kikatsi and Ms. Allen. So what we have is an individual that is basically propelled into acting as parent counsel with no preparation, coming in essentially.
I guess the question that occurs to me when you make that statement is, it's one thing to say, I didn't know there were any problems with the relationship between the counsel and the parent. It seems to me perhaps it's another thing to say that the guardian ad litem doesn't understand the record and doesn't know what the issues might be before the trial court in some detail. Is that wrong?
Yeah, I would agree with that. I don't think it's a situation where Rule 17 JL didn't understand the record or the issues at stake, but the amount of preparation that goes into termination of parental rights proceeding for a trial counsel is very different than what a Rule 17 JL is. And I think that's part of the reason why you're not supposed to have a Rule 17 JL act as the parent counsel. They are there in a different capacity. Moreover, they are subject to being called as a witness, and having a Rule 17 serve as an attorney essentially deprives the court of a potential witness in that circumstance. So I don't believe that my client had the advantage, or I shouldn't say advantage, I said the right to have counsel that was properly in place for that purpose, that went through the necessary preparations that you do as trial counsel versus a Rule 17 JL representing her in that hearing.
Would your remedy here be, instead of arguing that there's been a violation of the guardian ad litem statute, the guardian statute, rather to say that the trial court erred by denying the motion to allow the trial counsel to withdraw?
I think that definitely could have been the resolution to rectify this on the front end.
But you haven't made such an argument. You haven't contended before this court that the trial court erred by denying the withdrawal motion, have you?
I have not. I think that specifically the trial court indicated, based on the correspondence to the guardian ad litem, the Rule 17 JL attorney, and Mr. Kikatsi, that he was going to basically allow them to come up with a strategy to try to proceed, and that a strategy that they were left with without any kind of reasonable communication between Mr. Kikatsi and Ms. Allen was to have Mr. Hargett basically act as trial counsel.
The agency makes the observation in its brief that the mother refused to work with her attorney. What's your reaction then to the depiction that this is invited error, because if the mother had agreed to work with the attorney that she'd been appointed, then the GAL wouldn't have had to step forward and be more active in the process at the hearing?
Thank you for that question, Justice. To that, I would generally look at it a little bit sort of as I indicated in my reply brief. I don't think Ms. Allen invited the error. I don't think, clearly she was capable of working with an attorney. She had a good rapport with Mr. Hargett. She indicated a desire to have Ms. Joy Chappelle, who was originally appointed sort of accidentally to the TPR, and she had some interactions with her. So clearly she showed the ability to be able to communicate, to have an attorney that was representing her that she got along with and she was able to communicate with. It just so happens that the communication had broken down with Mr. Kikatsi at the point in time where the termination was started.
So you disagree entirely with the invited error concept that's been put forward by the agency, as well as the guardian ad litem, since the guardian ad litem has joined the DSS brief.
I do disagree with that. I don't think Ms. Allen, at no point in the transcript did she indicate she wanted Mr. Hargett to represent her ahead of Mr. Kikassi. She didn't ask for that. She asked for new counsel to be appointed. When the court denied that, she proceeded. I don't know that there's no indication in the record that she had any knowledge of what options she had that she could have gone down or pursued in light of that. She certainly didn't request that Mr. Hargett, who, again, she had not had conversations with pertaining to witnesses and evidence and testimony, when things were going to present, what to ask, what not to ask. Her correspondence with him, honestly, is a little bit questionable in of itself, in the fact that Mr. Hargett didn't even know that there were communication issues between her and Mr. Kikassi.
What is the proper role for a guardian ad litem in a circumstance such as this, when the guardian ad litem does, on one hand, have to make sure that the parent understands what's going on, but then on the other hand, the guardian ad litem does also have to make sure that matters are proceeding in a way that is to the benefit of the individual to whom the guardian ad litem is appointed?
I think ideally in this situation, the Rule 17 GL probably should have gone to bat for Mr. Kikassi and Ms. Allen, but specifically to the request for counsel being relieved or a continuance or something to allow that communication to be somehow corrected, or to have a chance to evaluate the potential of that relationship being corrected. If it couldn't, then to request some other counsel, or to join in the trial counsel's request to be relieved.
I want to ask if you would agree that in evaluating whether or not what the trial court did here was in compliance with the statute, that we should look to the question of whether the attorney representing the mother ever was absent from the courtroom, or did anything to indicate that he was not there, available, in control of how the presentation of her case was proceeding.
I think those questions, I think those questions have to be asked. There's going to be different ways that you're going to be able to tell. And like I say, I think from the record in this case, the amount of parent attorney role that the Rule 17 GL took on, and Mr. Kikassi obviously was present. He did make a few objections. He made 3 objections across the entirety of the hearing. He did question one witness on disposition. However, he didn't present any substantive arguments, and when asked on cross-examination, he would always indicate, I'm going to let Mr. Hardy do that. So I think the amount of involvement sort of speaks for itself from the Rule 17 GL perspective.
Well, I guess I'd ask a more limited question of what is the evidence that at any point in time, I understand your contentions about the relative roles that they had during the course of the hearing, but is there any evidence that her attorney at any point wasn't there and in complete control of how the case was being presented?
I don't think there was any evidence to indicate that Mr. Kikassi physically left the courtroom. That should be noted in a transcript. It was not specifically noted in this particular case. However, the specific deferral repeatedly to the Rule 17 JL is definitely obvious from reading of the transcript. Justice, if there's no other questions, I would just sort of circle back a little bit. And I know I mentioned a reference as sort of an alternative argument about ineffective assistance of counsel. Again, that alternative argument, I don't believe we have to even get to if we reach the point of error by the trial court by failing to follow the statutory mandate. I recognize that there was some level of representation there, obviously, but that is a collective view of both the parent attorney and the guardian and the Rule 17 guardian ad litem's efforts. Even if there was enough representation to prevent a finding of ineffective assistance of counsel, it begs the question of why do we, if we find that to be okay in the circumstances, why even have the rule in the first place? If it just happened to work out okay enough that that there was enough representation in this case, then it's okay that the trial court completely disregarded the statute. And that's probably the hardest part for me to swallow, is that a ruling against my client would basically afford the trial court to say at any point in time, as long as they're ultimately at the back end ends up being enough representation, then they can have this overlapping and basically disregard the statute, which renders it meaningless. In my opinion.
Counsel, I'd like to ask a question. Are you familiar with the N-Ray TNC case that is an ineffective counsel case, and the standard there of review when there has been a problem? Do you know what that standard happens to be?
Counsel's, it has been showing that counsel's performance was deficient, deficiency being so serious as to deprive the client of a fair hearing.
And is it your position? And is it your position that if there is ineffective counsel, assuming arguendo, that this did so seriously deprive her of a fair hearing?
I believe it did, and I don't believe we have enough. I don't believe the record gives us enough to be able to say that she didn't, because we don't know what could have been from proper representation from a trial counsel who's done all the things that would have to happen. Was there other evidence that was not brought in to play? I know that we had the pastor card who was presented on disposition very well could have been brought in on grounds specific to both neglect and regional progress, which were the two grounds that were ultimately found at the adjudicated stage.
And based on the record before us, though, do you see that that there was not sufficient evidence? Is that your position?
I would say the specifics of what exactly Attorney Kakasi could have accomplished can't specifically be discerned. Again, it's an alternative argument presented because I felt like it needed to be brought out to give this court a chance to consider it. My primary focus on this case is statutory violation, the rule being very clear and unambiguous, and the court's essential disregard, and basically precluding my client from having representation of parent counsel in the role that they're supposed to play.
Well, to follow up on Justice Barringer's question for a second, given that you've asserted an ineffective assistance claim on appeal, don't you have an obligation to make us, in order to succeed, don't you have an obligation to show that there's a reasonable probability that the outcome would have been different had things been done as you say they should have been done?
I would indicate there is a reasonable probability. It's sort of I may have misunderstood the question. I was thinking more about specific actions that could have been taken. I think it's sort of every action that a trial attorney defending a parent sitting in that parent role would have taken under those circumstances all come into question, because Miss Allen was showing progress there at the end. She had very significant and unique circumstances. She was suffered a brain injury as a result of being struck by a vehicle by a drunk driver, and suffered from seizures and memory loss. After that, she had her home burned down 2 months before Jason came into custody, and then her husband passed away in the first month of custody, who was her primary source. So I think that particular individual, there's a multitude of issues that could have been brought up and could have been explored in front of the court that were not even touched on hardly. And that absolutely would impact whether or not, in that specific case, whether or not that individual is likely to neglect going forward, or has not made reasonable progress, because reasonable progress doesn't measure by the individual.
So it's your contention then that you have, all you are required to do is say that something might have been different as compared to showing that additional, specifically showing that there's additional evidence that could have been provided and wasn't?
Justice, I would say that the information that I alluded to is what could have been brought, and had that been brought before the court, I think the court would have had to consider that. I do think there's at least a reasonable probability that could have resulted in a difference at the ground level, because Ms. Allen was showing progress.
Wasn't everything that you just recited contained in the record that was developed before the trial court at the hearing?
I would say that there's references to those, but as far as expanding on those and actually making those the centerpiece of the argument and understanding the uniqueness of her circumstances, that was not brought before the court, was not really not really expanded on in depth to give the court an opportunity to consider those, to have a reason to find against neglect and fail to make reasonable.
Okay, thank you.
If they please the court, I did take a little more time than needed, but obviously we had lots of questions there. I asked to be able to reserve the remaining time for rebuttal. Thank you very much for your time so far.
Thank you, counsel. We'll now hear from the appellee.
Honorable Chief Justice and Associate Justices, may it please the court, my name is Elizabeth Boone. I represent the Gaston County Department of Social Services in this appeal. With the court's permission, I would like to yield 10 minutes of my time to the attorney for the guardian ad litem for the child. This is the respondent mother's appeal from an order terminating parental rights. And in this appeal, the respondent has raised two very narrow issues for your consideration. And those narrow issues are whether the trial judge violated General Statute 7B 1101.1D and whether the respondent received ineffective assistance of counsel. It is undisputed in this case that the mother was appointed trial counsel and appointed a separate Rule 17 guardian. All three of those people appeared at trial. None objected to any of the actions that are now being raised. And the respondent has not raised any issue about abuse of discretion by the court or any issues about a breach of duty by her Rule 17 guardian. And of course, the appellant chooses the issues, but she's chosen to allege a violation of the statute. So this is a narrow issue for your consideration. Both sides agree that interpretation of a statute is a de novo review by this court, and that you look to the plain meaning of the statute and its legislative history and the legislative intent. This statute is entitled Parents' Right to Counsel and Guardian Ad Litem, and it provides very explicit procedural instructions for how and when the court considers and appoints a guardian ad litem and counsel for parents in the termination of parental rights hearing. The respondent is asking this court to take the words, "the guardian ad litem shall not act as parent's attorney," out of context and construe those to impose a duty on a trial judge to govern how a guardian acts. And my contention is that this misconstrues the meaning of the provision and extends it beyond the original legislative intent. I gave you some history in my brief, but traditionally a parent's attorney was also appointed as their Rule 17 guardian until about 2005. And there were some concerns raised by the North Carolina State Bar's Formal Ethics Opinion 11, and I attached that in my brief. And those concerns specifically were confidentiality and also conflict of interest. In response to that, the very first version of this statute, called 1101.1, was enacted in 2005, and it addressed those two concerns by eliminating our practice of having the guardian serve both roles. And it had a specific provision in Part C that said the parent's counsel shall not be appointed to serve as the guardian ad litem. And you'll recognize that as the first part of this disputed sentence. It also added the confidentiality protections that continue to today. And so it addressed both of those concerns from the ethics opinion. At that time, we had assistive guardians, and there was a provision E on our statute that's repealed. But that provision E, and the reason it's important, is it specified the only 4 actions that a guardian could take at that time. Later, of course, they added in Rule 17 guardians in the discretion of the court, and that created a lot of confusion. And then in 2013, this statute came into effect. And because the legislature eliminated assistive guardians, that required changes in provision C and provision E. So E, the limitations were completely eliminated, and provision C was modified. It kept the first sentence of parents' counsel shall not be appointed to serve as the guardian ad litem, and added that to that sentence, and the guardian ad litem shall not act as the parent's attorney. This was combined with in provision D that we have with those confidentiality protections. And of course, that is in line with the original intent of the statute when it was enacted to protect those two things, confidentiality and conflict of interest. So the respondent in his brief admits that the language requires two people for the two roles, but is contending today that this applies only to the first part of that sentence, and that the second part of the sentence places a duty on the trial judge to govern and monitor the actions of a guardian, and to make sure that the guardian does not act as counsel.
Ms. Boone, what do you think it means when it prohibits the guardian from acting as counsel? I mean, Mr. Michaels told us what he thinks it means. What do you think it means?
Yes, sir. I think it means what the original legislative intent was, that it means that two people are required for the two different roles. And my argument...
So your argument is, as long as two people are appointed, one person is guardian, one person is counsel, it doesn't, that's all that this provision requires?
Yes, sir. That's exactly my argument.
Does it matter for purposes of applying this provision what they then do?
Well, that's an important question, because, you know, a judge has the duty to govern the decorum in his courtroom, but that is reviewed under abuse of discretion. So an issue that could have been raised here is, did the trial court abuse its discretion in allowing the actions of the guardian ad litem? That was what was in your recent case. But what has been alleged narrowly is a violation of this statute. And my contention is this statute is procedural, how a court appoints somebody to be counsel or a guardian, and it is not governing the actions. And the reason I argue that this is mirrored language, because it says in the statute, you would think it would say counsel may not be appointed as guardian, guardian may not be appointed as counsel, but we do have Rule 17 guardians who are not licensed attorney. And so I think that's why there's a different languaging. But I think it was added because...
So again, to interrupt you just a second before I lose my train of thought if nobody else is. So in your view, then, there is no way that the guardian could act as the parent's attorney unless the guardian was also either appointed or retained to be the attorney?
Can you repeat that question, please?
All right, you said the statute says the guardian ad litem shall not act as the parent's attorney. What I've been trying to think about is, what does it mean to act as the parent's attorney? Is your argument then that the guardian never acts as the parent's attorney unless the guardian is either appointed to be the attorney or retained as the attorney in the event that you had a non-indigent parent?
I think that the reason behind the statute was to make sure there were two different people for the two different roles.
Right, and so are you arguing that as long as the person who is appointed the guardian is not also appointed as the lawyer or retained as the lawyer, that as long as one of those two things doesn't happen, there is no violation of the statute?
Yes, sir.
Okay.
And that's exactly what I'm arguing, because, you know, if you construe this the way the respondent has asked, then it would impose a different type of duty on the court, and it would require this court to sort of determine what is acting as counsel. And the legislature in the statute, nothing in it shows any way or any parameters to govern what is acting as counsel. And they had the perfect opportunity, if that had been the intention, to put that back into Section E that's sitting empty now, where we did prescribe what actions assistive guardians could do. But if in a reading of this, you're asking a trial judge to determine in every case, is the guardian acting as an attorney, then I believe the legislature would have put some kind of information in there so that we would have special limits to just delineate what is act as counsel. Otherwise, you have a Pandora's box of interpretations.
Well, you've been articulating exactly what you said in your brief as to why this would not be a per se violation of the statute, and appreciating what you said about legislative intent, and understanding as well what this court typically does in looking at the plain meaning of words for statutory construction purposes. why would it make a meaningful difference in your position as to whether or not the same person was appointed to be counsel for a parent and guardian ad litem as compared to when a person is allowed to act as both guardian ad litem and counsel for the parent?
And my argument would be that governing the actions of participants in the trial court falls under an abuse of discretion standard. And so that would be argued under an assignment of error that would say, did the trial court abuse its discretion in allowing a Rule 17 guardian to act as counsel? It would not be a statutory directive, especially where it falls in this statute, which is in provision D, with the confidentiality protections and with the traditional 2 people for 2 roles. So the intent seems to follow that that the same intent of the statute still exists. It has not changed from the time it was enacted.
Do you perceive here then to be, with your thankful dive into the legislative history, that there is some tension here between the plain meaning of the words and your historic discoveries in the legislative intent?
Well, I believe you can look at the language of the statute itself. I mean, even this comes from, he's pulled out half of a sentence. So the first part of the sentence is addressing counsel shall not be the guardian, and it's combined with an and, which usually sort of signifies the same meaning or the same idea. And then the second part would be illogical for it to mean, well, and now we're putting a duty on the judge to govern what a guardian does. And also, why would the statute also only govern what a guardian does and not what a counsel does? So my argument is that the intent behind the statute is just 2 people for the 2 roles, and that happened here without argument. And so there's not a statutory violation. And I would like to just real quickly.
I just want to follow up really briefly on whether the statute would be violated if, while there were 2 people appointed, the guardian was not a lawyer, and yet the trial court allowed the non-lawyer guardian, to do all the things that the guardian in this case did. Would that be still consistent with the statute?
And thank you. And I think that supports my argument that this is not the statute that addresses that. Because if you were asking a judge to interpret what is acting as counsel, what does that mean? Lots of different interpretations could be had. And so if the General Assembly intended for this to require a judge to determine in every case whether or not a guardian was acting as counsel, then they would have given parameters, just like they did in provision E when we had assistive guardians. I hope that answers the question. I wanted to say also that if you disagree with my legislative analysis, and if you do want to construe this more broadly than I think the legislature intended, then it's my position that the respondent would also have to show or allege prejudice. And in her brief, she has argued solely that this is error per se. And my argument is, in other types of cases that are about behavior, just because there's a statutory violation does not mean it's error per se. There also has to be a showing of prejudice, and the mother here didn't argue that at all because she solely argued error per se. And I would just give you a couple of examples. In the Hucks case cited by the respondent, that is a Chapter 15A where there's a clear statute that 2 counsel must be appointed if in a capital case and only one's appointed. Well, that's very clear. Here, our statute is not clear on what acting as counsel is, and so it's more of a decorum issue. So decorum issues are like a derogatory comment by a judge that requires a showing of prejudice, a Rule 17 guardian breaches his duty that requires prejudice, and ineffective assistance of counsel will require prejudice. So my argument is, even if you find a statutory violation, the mother has not even argued prejudice, and I think that's required to find error. And so that's a narrow issue. And the second narrow issue that she has alleged is whether or not she received ineffective assistance of counsel. And again, in our briefs, we agree that State v. Braswell, this court's case, is the standard to show that the counsel's performance was deficient or fell below an objective standard of reasonableness, and that the performance was so deficient that the respondent was denied a fair trial. And that is accomplished by showing prejudice. The Braswell case says it doesn't matter which prong you consider first. And the standard there, this is what the court says: if a reviewing court can determine at the outset that there's no reasonable probability that in the absence of counsel's alleged errors, the result of the proceeding would have been different, then the court need not determine whether counsel's performance was actually deficient. So while the respondent does not use the word prejudice in her brief, I'm going to address quickly the arguments that she made. The first is just an overall lack of involvement by her counsel. And this is not a specific argument of prejudice like what you would expect to see in these type of cases. It doesn't tell us what evidence was excluded, what objections were not made, what could have been done to affect the outcome of the case. But I will say this is not a completely silent counsel. He had limited representation, but he was there. He did make some objections. He did review exhibits. There's no argument that he missed an objection or failed to review anything. He did make a small argument to have the dependency grounds dismissed, and they were. And he'd been on this case since January of 2019, about 9 months. He had filed motions for her in the underlying case, and he didn't say anything negative about her, as in the Davidson case. So there were some actions taken. I also referenced in my brief some Court of Appeals cases where when parents didn't come to court, the attorneys made no sound at all. And in those cases, the Court of Appeals remanded because they said the record was silent and they wanted findings on why counsel acted like he did. But our record is not silent. We know from uncontested findings in the pretrial order, that's in the record at page 279, that the mother doesn't want this attorney. She's uncooperative with him. She's frustrated his efforts at representation. For example, transcript at page 6, he was prepared to offer Barbara as a witness, and she doesn't want him to. Uncontested finding number 6, the respondent has indicated her intent to contest the allegations of the petition, but has not communicated with Mr. Kukasi regarding a factual basis upon which to contest nor offer witnesses. So any argument that she was prejudiced by any deficiencies, I would say she has waived by her own actions. Calling Pastor Carr an adjudication instead, this is a tactical decision, and the record at page 117 and 118 is very clear that the judge allowed them time to go outside the Rule 17 guardian counsel and the mother to discuss whether or not to call witnesses at adjudication or best interest. So the mother was complicit in that. But even if she had, Pastor Carr very clearly said, I don't know if it's to the extent that she's able to take care of her child right now. So even with that, there was not enough to overcome the uncontested evidence and findings. So all of the findings of fact are uncontested here. They would be binding for this court, and the evidence finding as well. The record here is not silent on the reasons for any deficiencies by counsel, and I would argue to you that even if counsel's performance was deficient, the respondent has not shown any prejudice or anything that would have changed the outcome of this case. She's done nothing for 2 years. 2 months before the case, she finally got an assessment and tested positive for cocaine. And there is no amount of advocacy that could have refuted all of the uncontested evidence at trial or the respondent's own testimony. So under the Braswell standard, there's no reasonable probability that absent counsel's alleged errors, the result would have been different. Now, I recognize this is an unusual case, but there's only the 2 narrow issues that have been raised. And there may have been other issues that could have been raised, but she's chosen this statutory violation, which I contend does not even apply. That's a right to counsel statute, instead of arguing abuse of discretion by the judge. And she's not shown any prejudice. And also she's not shown prejudice to show an ineffective assistance of counsel. So I respectfully ask this court to affirm the termination orders and yield the rest of my time to Mr. Bernhardt. Thank you.
Thank you, Ms. Boone. Good afternoon, and may it please the court. My name is Brian Bernhardt, and I represent the child's guardian ad litem in this matter. I'm going to follow on a number of Ms. Boone's comments for both the ineffective assistance of counsel issue and the initial statutory issue, and I'll start with the ineffective assistance of counsel argument. As Justice Berenger and Justice Ervin mentioned during their questioning of the appellant, there is a standard set forth in re TNC that just came out last month. It notes the Braswell standard that the representation must be deficient or below an objective standard of reasonableness. But it also notes that the deficient performance must prejudice the parent, and that means that there must be a reasonable probability that the result would have been different, as Justice Ervin indicates. If we look at TNC, that came out a month ago today, actually, we note that it has two main underpinnings to its holding. One, that counsel's arguments and actions were altogether lacking in positive advocacy, and that it strains credulity to characterize representation as equal to no representation at all. As an initial matter, it's clear that notwithstanding appellant's arguments, the performance at the trial court level was not deficient. The argument is based on an overall lack of involvement by counsel, but if you look at the Department of Social Services brief, pages 19 and 20, as well as pages 24, there are a host of facts set forth in the record and the transcript that belie that argument. A motion for review was filed, objections were made, exhibits were reviewed, decisions concerning witnesses were made in conjunction with the mother. Pastor Kerr was not only called and testified by counsel, but positive testimony was obtained from him. And then, although appellant seems to discount it, it didn't happen until Mr. Kakassi asked for it. One of the grounds in the adjudication phase was actually dismissed. That's an important aspect because if there is an issue, there's one less issue on appeal. Also, we can show, based on what I've just said, that there was the arguments were not altogether lacking in positive adequacy. Pastor Kerr testified that mother's positive life progress happened in the months leading to the TPR hearing. She had community service with the church, and she had definitely come a long way. This is exactly as the facts were in re TNC, where counsel provided facts in the mother's favor, such as making progress in the case plan, speaking favorably about her, and showed positive traits. And as I mentioned, the dependency grounds were also dismissed. The representation was not equal to no representation. We showed that in TNC, the counsel unequivocally asked the court to rule in the mother's favor. And in this case, there's no doubt that Mr. Kakassi unequivocally asked the court to dismiss one of the grounds in the adjudication phase. That's in the transcript. It's in the order terminating the parental rights. The totality of the evidence.
Are we to look at this then as a court that if there is not some error that is shown by virtue of the guardian ad litem's advanced or more animated activity here in the dearth of an attorney acting the way that the attorney would be contemplated to act, that it's okay for this to take place?
The argument is that regardless of what the GAL did or did not do in this case, there are certain standards that must be met before a counsel can be determined to have been ineffective. The counsel must have represented the client efficiently below an objective standard, and as I was going to mention in a minute, there must be prejudice. Regardless of what the GAL did or did not do in this or any other case, in order to show inefficient representation by the counsel, you have to meet this other standard, the standards that were laid out, for example, in re TNC a month ago. When we get to that prejudice argument, as Ms. Boone mentioned, there's no showing of prejudice. There are no facts alleged of any prejudice by the appellant. And the case law in Braswell, the Braswell standard on page 562 of that case, specifically indicates that the burden of proof is on the appellant to bring forth facts showing that there's prejudice. Not only did the appellant not meet that burden in this case, but from my reading of the appellant's brief, the appellant did not bring forth any facts whatsoever. The appellant seems to be claiming that the counsel acted deficiently Therefore, it's automatically prejudicial. But that's not what the case law requires. The case law requires a showing of prejudice. The respondent needs to prove that but for the counsel's errors, there was a reasonable probability of a different result. And here we have no facts to show any prejudice, which means we can't show that there was any reasonable probability of a different result. And as Ms. Boone noted—
Sorry to interrupt you. But
yes, ma'am.
I do want to move to the first issue about the violation of the statute and get your perspective on whether the GAL would have been acting as an attorney, and whether it makes a difference in this case that the GAL was an attorney, and what would the statute have been complied with if the GAL had not been an attorney but had put on witnesses and done cross-examination and made objections in the way that the GAL did here?
So the answer to that question, I believe, can be found in the case of In Re PDR, which is a case cited by the appellant. If you go down to page 469 in that case, it's 224 NCAP 460, that case talks about the two roles of a parent GAL in a termination proceeding. One is to act as a guardian of procedural due process to assist in explaining and executing rights. But then, and I'm going to quote from the case here, a guardian ad litem is considered an officer of the court and as such has a duty to represent the party he is appointed to represent to the fullest extent feasible and to do all things necessary to secure a judgment favorable to such party. So in this case, and in other cases where the GAL is an attorney, the GAL has two roles: procedural guardian and to represent the parent. It's a different case, I believe, if the GAL is not a lawyer, because then you get into issues of the practice of law that's not allowed. That goes back to what Ms. Boone talked about as the original intent of the statute, trying to make sure that there's somebody there who can not only represent as an attorney, but also represent as a guardian. The confidentiality concerns she raised, the conflict of interest things that she raised, those are critical. And I think that there's a differentiation if you're not a lawyer. Here, we had a lawyer, and the cases allow the lawyer to do what allow the lawyer who is a GAL to do what the GAL did in this case, to cross-examine, to represent the parent to the fullest extent of the law. And if we go even further to a question that Justice Ervin asked earlier, which was, is there a line that we should draw? If you take the appellant's arguments out to its natural extreme, if the GAL had done nothing in this case, then the first issue that the appellant has raised wouldn't exist, because then the GAL would not have acted as an attorney. The GAL would have just kept quiet, and there would be no argument under the statute because the GAL would not have acted as the attorney. There would only be an ineffective assistance of counsel argument. But I don't think that's the public policy that this court or the state wants to impose. We don't want to tell a GAL, if the lawyer is not going to do what the lawyer's job is, that you should do nothing. We want the GAL to represent the client. And that is exactly what happened here, except it wasn't a function of the attorney not doing anything. As Ms. Boone outlaid in her brief and today, the attorney did a multitude of things to serve as an attorney. And if you look at the beginning pages, the first dozen or so pages of the transcript, it's clear that there was a disconnect between the parent and the attorney. And although it's not stated, it certainly appears that there was some strategic decision made to let the GAL handle most of the questioning. I'm sorry, Justice Hudson, did you have a question? I'm sorry, I thought. Are there any other questions? I think the last thing I'd like to point out in my last minute that I have is that the three cases that are cited by the appellant in this case supporting the ineffective assistance of counsel don't apply. State versus Staley is addressing what the judge's duties are and whether a judge did expressed an opinion. The reference to what the attorney did is simply to compare what a judge did with what an attorney is supposed to be doing. State versus Davidson is completely distinguishable. In that case, the counsel acted so poorly that the court ultimately said that it was altogether lacking in positive advocacy. The counsel made no argument in favor of the client, failed to plead for findings and mitigated factors, failed to advocate leniency, implied his own client was a liar, and actually noted that he was a bank robber. And In re DJ does not actually say, under my reading, what counsel for the appellant says. It's a case where counsel's representation, while not perfect, was vigorous and zealous. And that's what happened here. You may or may not think that counsel's decision and how they performed was perfect, but they acted zealously and vigorously. And therefore, we request that the trial court's TPR order be upheld and affirmed. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Chief Justice. Just if I could go back just a little bit there, I feel like the position being advanced by the Department, the Guardian, is essentially asking this court to read language into subsection D that's simply not there. It doesn't appear to me. I mean, the question from Ms. Boone, with all respect, was how does this doesn't govern action? And the very word "act" appears in there. In subsection D, is that the Rule 17 attorney shall not act as the trial attorney. So by its very words, it requires action being policed, and there's no better position than the trial court to ensure that. It's not difficult for a trial court to determine if a guardian ad litem has overstepped its bounds and gotten into the realm of acting as the parent attorney, especially when they do infinitely more than the parent counsel. In this case, the trial counsel actually forced the issue by not letting the additional trial counsel out and basically addressing both attorneys and indicating that treating them as a team, as if Ms. Allen had two attorneys, but they're not. They're just because, other than the fact that they are attorneys and they have familiarity with the case, they've prepared differently for that day. If the legislature had intended for that kind of meeting, I think we would see language like we see in 7B1108 and 7B601 regarding appointment of a guardian for a child, where it specifically states the appointment of an attorney for non-attorney guardians. We don't have any kind of language about that. What we do have is language that says that the Rule 17 JL is not to act as the parent attorney. Beyond that, the actual words from Mr. Bernhardt asked this court to consider a hypothetical scenario where if the GL attorney hadn't acted as the attorney. By that an argument, acknowledging that the guardian ad litem attorney, the Rule 17 JL, did act as the trial counsel. That's sort of where the rubber meets the road to this argument, is that these are clear and unambiguous statutes. It's not complicated. There's two roles, and they shouldn't be intermingled. And it's important that they not be intermingled because they are distinctive roles that are put in place to protect the most precious of rights. And I do believe that by allowing this to happen, that Ms. Allen was in fact prejudiced in this circumstance by having essentially somebody that was not prepared to trial the case, walked up and said, "You got to do this." And he only had a minimal time to prepare. Again, there's no evidence in the record to indicate that he had conversed with any of her witnesses, had any indication what the evidence from her witnesses would be, that he had reviewed the discovery and prepared specifically to try that. But regardless of whether he had done that or not, the trial court overstepped and violated the statute by putting them in that situation in the first place. And that's where the argument is focused for Ms. Allen. It is an easily resolvable issue that could have been taken care of by the trial court. But the trial court was dead set on hearing this case. The trial court did not want to allow counsel to be relieved and had no interest in continuing it further, forced the situation, forced the issue, and basically said, even if he acknowledged the statute, he ignored it. And it's not complicated. The statute's very straightforward. The trial court elected to not follow it. He had the ability to do it. He was in position to do it. It's not complicated at all to police that. The trial court remains in the best possible position to police it. They handle the appointment of the attorney. They handle the appointment of the Rule 17 JL, even deciding to appoint that Rule 17 JL in the first place. They can certainly decide whether or not the parent attorney, the Rule 17 JL, has acted as a parent attorney, and to assume that places some sort of undue burden on the trial court, I would indicate, it's unreasonable there to make that argument, because the trial court is there. Its job is to make sure that there's a fair proceeding especially in these circumstances where we're talking about the parental rights to a parent. I mean, these are essential rights that can't be like, well, they violated the statute here, but it's okay because A, B, C, and D. That's not at all considered in the statute is what occurred in this particular case. And it allows a trial judge to essentially disregard it based on his convenience, because he wants to proceed with this case and he's ready to terminate this parent's parental rights. And I humbly ask this court not to find that way, to recognize the argument in favor of statutory violation of the statutory mandate, the fact that my client was in fact prejudiced by not having her prepared trial counsel actually handle her case, and that this case be remanded to Gaston County for a new trial. I would yield the remaining 6 seconds unless there's other questions.
Thank you, counsel. Thank you, everybody. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court.
Thank you, Justices.
Thank you, Justices. Thank you, Madam Clerk.